Looks like we've got everyone. All right. Mr. Biasotti, you're up.
Good morning, Your Honors, and may it please the court. My name is Robert Biasotti, and I represent Wise Property Management. I'd like to reserve 5 minutes for rebuttal, please.
Sure.
Thank you. This is the second time that Wise and Hampton have appeared before this court. About a year ago, there was an oral argument on the settlement agreement, and the settlement agreement required Hampton Park to hire an attorney, not from Bush Ross. And so they hired an attorney. They hired Anthony Martino. He was their attorney. They used his engagement letter to prove that they met that element of the settlement agreement, and the trial court, this court affirmed the trial court's decision that they met the settlement agreement. Thereafter, Hampton Park sought and received an award of $11,628 for Martino's attorney fee. And that was wrong for 3 reasons. First of all, the settlement agreement required them to hire and pay an attorney. They hired Anthony Martino. Since he was their attorney, he cannot be their expert as a matter of law. Second, to the extent that Hampton Park's attorney provided legal advice to the court on the interpretation of insurance policies and the interpretation of ethical rules under Florida law, that's not appropriate for expert testimony. These are legal decisions that the court is responsible to make. Attorneys can guide the court, and certainly Mr. Martino did that, but he was not an expert on contracts, on insurance contracts. You can't be an expert for that. The trial judge made the legal determinations, but Mr. Martino did not provide expert legal opinions. And third, what the court said was that, well, he justified this because an attorney is like a CME, a doctor providing medical advice. Well, it's not. A lawyer is not a doctor. Yes, a trial judge needs a doctor to give doctor opinions, but a trial judge who's a lawyer, just like the rest of us, does not need an expert to tell him what a contract says. Let me rephrase that. It's okay for an attorney to advise the judge or give the judge's help in interpreting the insurance contract, but that's not an expert. That doesn't define, that doesn't fall under the expert in 90.702 testimony by experts. Typically, experts talk about facts and why those facts make a difference in this case. There are no facts. Mr. Martino had no idea what the facts of this case were.
When Mr. Martino was asked to testify as to the meaning of the contract and how the provisions interacted and interrelated, was there any objection?
Yeah, let me be clear about that. No, not specifically. We did not object to him giving his opinions of what the contract said. That's not the point. What we're objecting to is he's not there as an expert to receive an expert opinion. I'm an expert. All you judges are expert. Certainly Mr. Brian Hull is an expert, but we don't get reimbursed for that. Did we object? Yes, we objected numerous times that his testimony—
Was he a fact witness then? Is that what you're suggesting?
No, he was not a fact witness.
So what was he?
He was their lawyer pursuant to the agreement, and he testified to what the contracts, the insurance contracts said.
He was not representing them in the case, though, was he?
Yes, he was. Absolutely.
He had appeared in the case?
He provided—
Did he appear in the litigation?
Yes, and let me explain why. There was a settlement agreement. The settlement agreement required that they hire an attorney. the judge would not
And the
know.
attorney was to be hired to give them legal advice.
Yes, and they used his, Mr. Martino's engagement letter to show that they met the part of the settlement agreement. So to the extent that he appeared by his engagement letter as satisfying the qualification of the settlement agreement, yes, he did appear in this case. Did he provide extensive testimony on the legal implications of the contract? Sure, yeah. There's nothing wrong with that. The question is, do I have to pay their attorney's fees for a quote expert who's giving legal opinions, not fact opinions?
Mr. Biasotti, kind of two related questions. Would your argument remain the same then if if a lawyer other than Mr. Martino had provided the exact same testimony as Mr. Martino? And relatedly, could that testimony, when viewed as a whole, be viewed not so much maybe incidentally talking about the interpretation of a contract, but more providing a lay of the legal landscape to say, look, no plaintiff's insurance lawyer would take this case given this policy. And in that respect, liken it to, we see this sometimes in insurance coverage cases where a successful plaintiff seeks a fee multiplier, and the argument is about how difficult this case is, and are there other lawyers out there that would take it? That came to mind as I was reading through this. Can you help me out with that?
Yeah, I can, absolutely can. The only time an attorney can appear as an expert is to discuss fees and multipliers. That's the only time that they can give fact information. What's the normal fee for an attorney in your jurisdiction? Why do you need a multiplier? Those are fact issues on a case. And if you look at the answer brief in this case, they cite 10 different cases. And the one that you're referring to is the last one, in re estate of Asamakako. I might have gotten that wrong. But all of those cases where an attorney testifies to a fee, that's an expert opinion. Now, let me get back to your first question. If he wasn't their attorney, could he possibly get fees? And I would say there are two answers to that. One, but he was their attorney. That's their whole point. The only reason we're even here is because he was their attorney. Because if he wasn't their attorney, they did not satisfy the settlement agreement, and we should have won the first appeal. But regardless, when you're giving a testimony on the legal interpretation of a contract, you're getting into something that the judge is required to do. You can help the judge, but you're not an expert. With all due respect to Mr. Martino, who's an excellent lawyer, he's no more of an expert on a contract than I am, or certainly the judge was in this case. In this case was Judge Barbas. Did that answer your question, Judge Lucas?
Thanks.
I commend the court, and I'm sure Mr. Hull will have his time, and maybe I'll get a little rebuttal. He cited 10 cases. We've distinguished every single one in the reply brief. I commend that to you if you have any questions. There is no case in Florida where an attorney wears a dual role. He represents a client as his attorney, and he testifies as an expert. None, no cases. None of the 12 cases he cited. And frankly, it would be wrong. You're somebody's attorney. I mean, I suppose I can get costs for arguing this case here because I'm arguing, the law and everything to you. Am I an expert? No, I'm an attorney. I have a fee agreement with my client, as Mr. Martino did. So he's not an expert. He was a hired attorney, which in this case, he had to be a hired attorney in order to satisfy the settlement agreement. If no other questions, I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Pisani. Mr. Hall? Was I muted? Mr. Hall, you're up.
Thank you, Your Honor. Just a minute. I'm working on getting my screen in the proper view.
I got you. Life in the pandemic.
May it please the court, I am Brian Hull on behalf of the Applee Hampton Park Townhome Association. This appeal asks whether the trial court abused its discretion by awarding the costs of an expert witness when the appellant agreed he could testify as an expert and never made a timely, contemporaneous, specific objection to the admissibility of his testimony. First, we will address the question of whether Mr. Martino was a fact witness or an expert and whether he represented a party. And then we will address Wise Property Management's failure to object to the testimony of Mr. Martino when he testified as an expert witness for Hampton Park. Then I'd like to touch upon some arguments about cases involving awards of costs for attorneys who testify as expert witnesses. The case below involved the settlement of Hampton Park's claims that an employee of Wise had embezzled approximately $800,000 from Hampton Park. In the settlement, Wise assigned its rights under certain insurance policies and a bond to Hampton Park, and Hampton Park agreed to pursue them in good faith. After an evidentiary hearing, the trial court entered final judgment in favor of Hampton Park, finding that good faith did not require Hampton Park to file lawsuits or pursue claims where there was no coverage under the policies or the bond. In other words, pursuit of the policies and bond would have been futile, and another panel of this court affirmed. Mr. Martino testified at the evidentiary hearing as an expert witness on insurance coverage issues. And before I get to his actual testimony and what happened there, I'd like to touch on a couple of points. He had a retainer agreement that Hampton Park executed, which specifically provided that he would not be representing Hampton Park. He was only in the position of acting as an expert witness and rendering an opinion letter. And then Mr. Martino provided an opinion letter. And in his opinion letter, he says, "I state specifically herein that I do not represent any parties in this matter and have been retained solely as an expert." And then when he was questioned at the evidentiary hearing, he specifically stated that he was there not in the capacity of representing any party. He was only there to testify as an expert witness. So turning to his testimony, Mr. Martino offered an opinion on whether there would be coverage under the insurance policies and bond for the claims that Hampton Park had filed against Wise. Before the hearing, Wise's counsel had agreed that Mr. Martino is an expert on insurance and stated that he had no issue with Mr. Martino opining what would and would not be covered under the policy. During the evidentiary hearing, Wise stipulated to the admissibility of Mr. Martino's expert report, which was the opinion letter I referenced a couple minutes ago. And in that opinion letter, Mr. Martino opined there was no coverage under the policies or the bond. Hampton Park tendered Mr. Martino as an expert witness, and Wise did not object. Hampton Park then went through each policy and the bond, asking Mr. Martino whether they would cover the claims. At that point, Wise did not object to any of Mr. Martino's opinions about coverage under the policies. And throughout the evidentiary hearing, Wise treated Mr. Martino as an expert witness. The trial court recognized Mr. Martino as an expert witness. The trial court structured the hearing so the expert witnesses would testify first. So during that hearing, Wise asked numerous questions about coverage. Wise even posed its own hypothetical coverage questions to Mr. Martino. Then Wise called its own expert, another attorney, Garrett Rains, and Mr. Rains had not reviewed the specific policies because he had a potential conflict of interest. But Wise elicited his general opinion about what is covered under these types of policies and whether he agreed with Mr. Martino's coverage opinions. When the parties gave their arguments at the end of the evidentiary hearing, Wise never suggested the trial court could not consider the expert testimony because it involved a question of law. And Wise never suggested that the trial court had to make an independent determination of coverage as a matter of law. Neither party asked the trial court to interpret any specific policy language to determine whether there was coverage. That was not how the parties presented their case to the trial court. And that was precisely what Judge Silberman observed the last time we were here for oral argument in this case. And at minute 13 of the argument, Judge Silberman noted, the court wasn't asked to make an independent determination of coverage by reviewing the insurance policy. The court was presented with testimony to explain whether there is coverage or not. So now on appeal, in its reply brief, Wise suggested it raised a general objection to the trial court considering Mr. Martino's opinion testimony. And Wise pointed to 5 different places in the record. And since that was in the reply brief, I'd like to touch on those here. Only one of those objections that Wise pointed to actually came during the evidentiary hearing. And that objection did not even deal with the same specific issue that Wise is arguing on appeal. Wise only objected that Mr. Martino could not offer an opinion on how to interpret the parties' settlement agreement, not the insurance policies. And specifically, the settlement agreement provision requiring Hampton Park to proceed in good faith. And that's not the opinion that Mr. Martino ultimately offered at the evidentiary hearing, and it's not the opinion that Wise is now challenging. As for the other 4 objections that Wise points to, all of those came after the entry of final judgment. They were in its motion for rehearing, Wise's amended motion for rehearing, the hearing transcript from the motion for rehearing, and then later on at an evidentiary hearing on the amount of expert costs Mr. Martino incurred. All of those objections come too late. Florida Statute 92.231, subsection 2 requires an award of costs for any expert or skilled witness who shall have testified in any cause. A party cannot avoid these costs by making a belated objection that the trial court should not have permitted the expert to testify. And one other point I did want to address is that Mr. Martino has never appeared in this case. Mr. Martino has never represented Hampton Park in any sort of claim against Wise. At most, he was asked his opinion on coverage involving claims that Hampton Park had against Wise and Mr. Murphy. And potentially, Mr. Martino anticipated that if he found coverage, then he might be hired to pursue claims against the insurance companies. He was never hired to represent Hampton Park against Wise and never entered an appearance in any case that Hampton Park filed against Wise. And very briefly, I'd like to turn to 3 cases from this district that were mentioned in the parties' briefs. There was Lee County versus Barnett Banks, the state of Williams, and Han v. Belleau. And the first point that I'd like to make about those 3 cases is that there is nothing in any of those cases that would suggest the court reviewed an unpreserved argument about the admissibility of the attorney's opinion testimony. And in fact, the Han case made very clear that the party had indeed raised a timely, contemporaneous objection that the attorney's opinion testimony was inadmissible because it involved a legal question. And the second point I'd like to make is that these 3 cases involve situations where the attorney's only testimony involved an opinion on a legal question. And here, Mr. Martino did not only offer an opinion on whether there would be coverage under the policies and bond. As Judge Lucas just recognized, Mr. Martino also offered an opinion on whether Hampton Park could have retained an attorney to pursue the claims against Wise. And Wise only made a single objection to that testimony, and it was that it went to the ultimate issue in the case. Wise never argued that it was a legal question just for the trial court until its reply brief, and that's too late. And the final point I'd like to make is to touch on the analogy that the trial court used here. The trial court compared Mr. Martino's role in this case to a doctor who gives a compulsory medical examination in order to justify awarding only a portion of Mr. Martino's fees. And the trial court considered Mr. Martino's opinion letter as an initial valuation that was necessary to satisfy the condition precedent in the settlement agreement. And so the trial court declined to award that portion of his fees. But there's really no question that after that point, Mr. Martino was solely and completely an expert witness. His retainer agreement, his opinion letter, and his testimony all make very clear that he was not providing legal representation to Hampton Park. And I would submit that it would be no different if Hampton Park had hired Mr. Martino to write the opinion letter and then hired a different attorney to provide the opinion testimony. It doesn't matter whether it's one attorney or two attorneys who provides these separate roles. Hampton Park was entitled to an award of fees for the expert's testimony and preparation time, regardless of whether it was one attorney or two separate attorneys, and regardless of whatever analogy the trial court may have used. So in summary, Wise cannot now complain that the trial court should not have permitted Mr. Martino to testify as an expert on insurance coverage. Wise agreed he could testify as an expert on coverage, stipulated to the admissibility of his report, did not object to his testimony at the evidentiary hearing, and even treated Mr. Martino as an expert. When an expert testifies without objection from the other party, the statute requires an award of attorney's fees, an award of the expert's fees as a cost. And so the trial court was well within its discretion to award Mr. Martino's fees. And if the panel doesn't have any questions, I would submit that the order of the trial court should be affirmed.
Thank you, Mr. Hall. Mr. Biasotti.
Yeah, I'll go back to the case that was just cited, which I lost my notes on. The Hahn case, 9/20, 7/2, 1250. And what the opinion says is, states, quote, opinion testimony as to the legal interpretation of Florida law is not the proper subject for expert testimony. The thing that we're getting confused here is an expert in what? What is it that Martino was an expert of? The interpretation of a contract? Yes, he is an expert of that. Is that a compensable expert fee type of expert? No, it doesn't meet the expert statute, which generally get into fact issues. There is no question that Mr. Martino knew nothing about the facts of this case. He read the 5,000 pages of the contract. He gave his expert opinion on that. We didn't object to that. What we objected to is them backdooring their attorney's fee by calling their attorney an expert. And number one. Number two, we're sitting here in front of this court, and Mr. Hull is right. He made the statement to Mr. Silverman 1 year ago. And the reason they won on this case is because Anthony Martino was their attorney. That's what satisfied the settlement agreement. The settlement agreement required that they hire an attorney, not from Bush Ross, because Bush Ross actually represented my client when this case started. They didn't want Bush Ross to represent him, to hire another attorney. So the last time we were in this appeal, they were jumping up and down saying, yes, Anthony Martino represented us. And that satisfied the settlement agreement. The actual, and I cite it in the brief, and I urge you to go to the trial, record 355, 35, 33 to 34. And the appellee's attorney said to the court, so Your Honor looked at this and said, well, the agreement says you should retain counsel. So there should be an engagement letter. You should present some evidence from counsel. So we retained Mr. Martino, Anthony Martino. That's how they satisfied the last case. It was all about getting $100,000. They got their $100,000. Now they want $11,500 additional to pay their attorney his attorney's fees. He was not an expert. We did not object to him being an expert when he testified, because he was testifying to contracts, contract interpretation, not fact issues, not things for which an expert is required. And I say again, and I challenge everyone on this panel, find a single case where a retained attorney is given costs as an expert. There are some cases where attorneys testify as expert on fees and on multipliers. And there are even some cases where a non-retained attorney, not representing a party, can testify in a case. But there is no case, and I challenge anyone to find it, where a retained attorney is treated as an expert and part of his attorney's fee is paid as costs. There is no case. That should not be the law in Florida. It should not be the law in this case. And this court should reverse the order on appeal, reverse the $11,528 for expert fees. Thank you.
Thank you, Mr. Bizzatti. In order to leave this virtual courtroom, you need to click the red leave button on your Zoom screen, and then when you do, we'll call the next case.